Judgment in the appeal MA Somalia and the Secretary of State for the Home Department.
The judgment of the court will be given by Sir John Dyson.
The issues raised in this appeal are, first, the correct approach to the relevance of lies told by an asylum seeker in the assessment of real risk of persecution of a person on return to his or her country of origin, and secondly, how far it is legitimate for an appeal court to interfere with the assessment of facts made by a specialist tribunal on the grounds of error of law. As regards the issue of lies, the tribunal found that the appellant's account was incredible, but in this case, as in many others, there was undisputed general evidence about the country to which the Secretary of State wished to return the appellant, which showed that most of the persons who fall into the category claimed by the appellant are at risk of persecution, but that a minority, because of special circumstances, are not subject to such risk. In a judgment prepared by myself, the court has held that where a claimant tells lies on a central issue, his or her case will not be saved by general evidence unless that evidence is extremely strong and sufficient to counteract the negative pull of the lies. The tribunal directed itself correctly as to the relevance of lies. As regards the second issue, the appellate court should not characterize as an error of law what in reality is no more than a disagreement with the tribunal's assessment of the facts. The Court of Appeal was wrong to interfere with the tribunal's assessment in this case. The appeal will therefore be allowed.
Judgment in the appeal of Royal Bank of Scotland against John Wilson and Royal Bank of Scotland against Francis Wilson.
The judgment of the court will be given by Lord Roger.
The appeals raise questions as to proper construction of provisions of the Conveyancing and Feudal Reform Scotland Act 1970. The appellants are two married couples and they are proprietors and occupiers of their homes south of Edinburgh. Their homes are subject to a standard security granted by each couple to the Royal Bank of Scotland in 1991. In each case, the amount secured was any sum which the husband and wife owed or might owe to the bank, whether jointly or as individuals. In 1992 and 93, the husbands, who were brothers, undertook to repay to the bank any indebtedness of the two firms in which they were involved. 2 years later, the bank wrote to each of the brothers demanding repayment of the amounts which were then overdrawn on current accounts of their firms. When the sums were not paid, the bank took steps which were intended to allow it to sell the couple's homes. It was at this stage that the wives became aware that their homes were at risk of repossession by the bank. The bank then applied to Edinburgh Sheriff Court for an order to eject the couples from their homes. The Sheriff declined to grant the order on the basis that the bank had not made a formal requisition for payment as required by one of the relevant statutes. The bank appealed to the Court of Session. An extra division held that a certificate which the bank had lodged in court in accordance with a provision of the 1970 Act constituted the necessary formal requisition. The couples appealed to the Supreme Court. For the detailed reasons given in the judgments, the Supreme Court unanimously allowed the appeal and held that the bank is not entitled to eject the couples. In particular, the court held that the bank had not made the necessary formal requisition before beginning proceedings for ejection. The court also held, contrary to previous authority, that since the bank had intended to sell the couple's homes, if the debt was not paid as demanded, they should have used a different procedure and served a calling up notice on the couples.
Judgment in the appeal of Holland and the Commissioners for Her Majesty's Revenue and Customs.
Some years ago, Mr. and Mrs. Holland set up a business whose purpose was to administer the business and tax affairs of contractors who did not want to go to the trouble of setting up and running their own companies. Their business model involved the creation of a number of companies, referred to in this litigation as the composite companies, whose function was to contract out the services of the contractors to their clients. The contractors became both employees and shareholders of the composite companies. The aim of this unusual structure was to seek to ensure that the annual taxable profits of each composite company were such as to entitle each of them to obtain the benefit of the small company's rate of corporation tax. Part of the income received from the contractor's clients was paid to each contractor as an employee of the company. The companies also declared dividends, which were payable to each contractor as a shareholder of the company. The dividends were paid regularly on the basis of timesheets which the contractors had submitted for the work they'd performed for their clients. Two further companies called Paycheck Directors Services Limited and Paycheck Secretarial Services Limited were created to act respectively as the sole director and secretary of each composite company. Mr. and Mrs. Holland were the directors of these two companies. A software program was used to calculate the dividends as they became due and to generate a document purporting to be a minute of the directors' meeting of the relevant composite company. The program generated onto the minute a copy of Mr. Holland's signature authorizing the dividend, beneath which appeared the words "for and on behalf of Paycheck Directors Services Limited." No allegation was made that this structure was a sham, and there was never any pleading of dishonesty against Mr. and Mrs. Holland. But the structure failed to achieve its object because Mr. Holland was held to be the settlor of the share which he held in each composite company, with the result that the composite companies failed to be treated as associated for tax purposes. This meant that the planned tax advantage was not available, and the income of the composite companies, when taken together, exceeded the small companies' rate threshold. As all of the income had been paid out to the employees and shareholders, the composite companies were unable to pay the increased tax liability. This meant that the companies were insolvent, with the revenue being the only creditor. Section 212 of the Insolvency Act provides that in this situation, a person who is or has been an officer of the company who has misapplied any property of the company may be compelled to make good the loss to the company which has been caused by his misfeasance. The director of the composite companies on whose authority the dividends had been paid was the company called Paycheck Directors Services Limited. But the revenue argued that Mr. and Mrs. Holland were de facto directors of them, and as such, responsible under that section for causing the payment of dividends to the company's shareholders when the companies had insufficient funds to meet their liabilities. It sought orders requiring Mr. and Mrs. Holland to pay amounts in excess of £13 million to compensate the insolvent companies. The High Court dismissed the claim against Mrs. Holland, and that decision was not appealed. However, the High Court held that Mr. Holland was a de facto director of each composite company, and so in principle answerable to the revenue's claims. The Court of Appeal unanimously allowed Mr. Holland's appeal and held that he was not a de facto director of the composite companies. The Supreme Court, by a majority of 3-2, has decided to dismiss the appeal. In the opinion of the majority, the question was whether, in relation to a company whose sole director is a corporate director, such as Paycheck Directors Services Limited, liability under Section 212 can be imposed on a director of that corporate director when all of his relevant acts were done as a director of the corporate director and can be attributed in law solely to the activities of the corporate director. They held that this question had to be answered in the negative, and that as everything that Mr. Holland did was in his capacity as a director of the corporate director, it was to that capacity alone that his acts were in law to be attributed. In the view of the minority, it did not follow from the fact that Mr. Holland did what he did in his capacity of the corporate director of the corporate director, that he did not also do it as a de facto director of each composite company. As it was clear on the facts that this was what had happened, they would have allowed the appeal. The court will now adjourn.